Hi, my name is Julian Castle. I'm with the Real Estate Investors Group, and today I have a very special guest. His name is Sean St. Clair. Sean is a creative finance lawyer who works out of Arizona and also has an office in Georgia. And today we'll be talking about how he helps real estate investors like us make better transactions and get through the process. So, Sean, how you doing today?
Doing well, Julian. How are you?
Doing well. Good to meet you.
Yeah, likewise.
Sean, for the real estate investor who potentially is used to doing things that are a little bit more normal, like having traditional bank loans and may not know about some of these creative financing strategies that other real estate investors use very successfully. What is creative finance and what are some of the strategies?
So, in a nutshell, creative financing is figuring out how to purchase a property without using your own personal funds or obtaining some form of traditional bank financing, right? I mean, that ultimately is creative financing. And so, the different strategies are seller carryback financing, where the property is owned free and clear, and the seller is going to basically become the lender. So that's one strategy. Another strategy is that there's a loan against the property, and it's a low interest rate loan, and you basically want to be able to take over the payments on the loan on behalf of the original borrower and the seller. And so, that's called a subject to transaction. There's a number of ways to structure subject to transactions. You can do a wrap, which is, basically giving the seller a promissory note secured by a deed of trust or mortgage, if you're in a mortgage state, which basically says, hey, I, as the buyer, am going to pay your loan for you. And if I don't pay, you can come in and, foreclose on me. Another is an agreement for sale or contract for deed. That's basically where the title to the property remains with the seller, but you say, well, I'm going to perform as the buyer. I'm going to make the monthly payments on your loan. And when I'm all done, I'll have performed, and then you'll give me title to the property. And then the third is a lease with an option to purchase. Generally, the lease payments will be structured so that they are mirroring the existing mortgage payments. And so you then write, those checks to the lender as part of your lease payment. And then you have the option to purchase. And that can be structured a number of different ways, but it gives you the ability to basically be the one to purchase the property should the time come, or should you pay off the lender.
Amazing. So why isn't it so talked about, subject to transactions, for example, that many investors really don't know how to do it?
I think it's talked about. I think there's a number of, investors out there that, are getting the word out, and it's well known. I think investors don't do it because they don't fully understand it. They don't know how to approach the acquisition side of a subject to. How do you basically explain to the seller, hey, um, the things that we traditionally do in real estate, like you sell to me, I pay off your loan, I own your property. We're not doing that today. Instead, I want your loan to remain, and you'll remain the borrower, and it will still be on your credit. And, granted, I'm saying all the bad things, right? And so there's ways of presenting it to a seller in different terms that I think investors are uncomfortable with. And so they would rather take a more conservative or traditional route to investing than trying to, figure out how they're going to approach a seller, what they're going to say, how they're going to explain it, and that type of thing.
That's great. Yeah. And how is it important to have a good lawyer when you're doing some transactions like these?
I mean, I think it's critical. So as you were saying in the intro, I'm licensed in Arizona. And so I work out of our firm's, Scottsdale, Arizona office. We have a Georgia office that's staffed by two attorneys in Georgia that are licensed there. I'm not licensed in Georgia.
Hmm.
But as far as, having an attorney involved, for me, it's critical, because if your documents aren't right, if you're not giving the right disclosures, you're going to end up in hot water. So, for example, in Colorado, they have these things called foreclosure rescue laws, and they basically apply to anybody that they call an equity purchaser. So basically anybody acquiring property with any form of equity in it, like subject to transactions, those types of things. And if the loan is in default, and default is defined as not foreclosure, but default, meaning it's more than 30 days past due. So there could be no trustee sale, and all the seller is 30 days late. And if they are, then there's very specific disclosures that you have to provide to the seller in your purchase contract. You have to give the seller the right of rescission in that purchase contract. And if you don't give them those things, there's significant penalties that come from not doing that, even after you close the transaction.
Yeah, so
it's important to have an attorney involved.
Got it. So one of the people that you helped out, which is he's a pretty popular figure, is Pace Morby, correct? And he talks about the subject to agreements, and there is a very important aspect to it, which is, of course, disclosing the things to the seller, plus having the right disclosures there so that the seller and you are on the right terms. So if it goes into some legal battle, you're protected, right? What can someone who's looking to get into these transactions learn about how to work with a lawyer, or how to find the right lawyer, for example?
Well, finding the right lawyer is actually difficult. So there are, they're difficult to find. There's, in my view, maybe a handful of attorneys out there that really know this on a high level. I try, my best to kind of pull the attorneys together. So we have a weekly podcast called In Rim, the Law for Real Estate Investors. That's every Tuesday at 10 a.m., where we interview attorneys from all over the nation on, issues of creative finance, wholesaling, securities, syndication, those types of things. In addition to that, we have the Creative Finance Collective, which is, Wednesday nights at 5 p.m. Arizona time, which we bring, basically it's attorneys who are in the creative finance space from all over the country who sit around and just talk shop for an hour. And anybody can sit there and watch and learn and listen to some of the things that we discuss. Starting there is good, because then you're starting to see and get familiar with the attorneys in different states. But really just getting connected, social media is a good way to join groups like your group, the Real Estate Investors Group, put out a post. Hey, I'm trying to do a subject to in this state. I need a good attorney to review, my documents or to draft my documents. Who do you recommend that knows it? There's a lot of title company. You need a title company that knows subject to as well. So, that same post, hey, I'm doing transactions in this state, who has a good title company that understands subject to. But really, you have to do your research. You have to find those people. It doesn't hurt to have mentors, to join masterminds, to join, like I said, social media groups, to join, meetups. So, even myself as an attorney, I go to probably 2 to 3, actual physical meetups per month, different locations, just to network, to learn, to, just stay up on what's going on in the investor realm. So, you just have to be out there. You have to go outside of your space, outside of your office, and do the research you need to figure out, who knows this stuff, who's capable, and, make sure that you're working with an attorney in every state that you're operating. Because you may have a form that you think is great, and it probably is good. If it was drafted by an attorney that knows this space, it's probably good, but it was probably, and well, I know it was drafted by that attorney for the state in which that attorney is licensed.
Mhm.
So if you want to use that form, that's fine, but make sure to go and say, "Hey, I'm investing in Colorado. I know they have these foreclosure rescue laws. I need to connect with an attorney in Colorado and give them this contract and be like, hey, what do I need to add for it to be compliant with Colorado law?" And then they can take that contract and add the magic language that you need to make sure you're doing it right in Colorado.
That's interesting. And what, how does, how much does a lawyer run? Like when it comes to, obviously, everybody's different in the terms of the rates and everything. But if you're looking for a lawyer that's good, that is in creative financing, maybe that's one of your podcast guests, what is a typical range that someone would have to budget into the deal when they're working with an attorney?
I would say to basically get the documents that they need and to have the attorney prepare the documents for that transaction, anywhere between, $1,500 and $3,000 is kind of the range you would be looking at as far as this is the attorney I'm going to hire. They're going to fill in the forms for me. They're going to, create the purchase contract. So for us here in Arizona, our clients, they come to us, say, okay, and we represent, if we don't have a conflict, we represent a seller who is doing subject to. And honestly, we have different contracts for that because the seller understands what they're doing and they're, selling maybe to an end consumer that doesn't fully appreciate the nature of the transaction. We want to make sure that they do. So we have different disclosures and stuff for that. But we'll represent a seller, we'll represent buyers who are wanting to, purchase creatively. And basically, we'll give them the price. And like I said, it's going to be below 2,500. We'll give them the price. We put everything together and then we send it to the title company and they're off to the races. And the title companies that we use know how to do this transaction. So frankly, once we put the contracts together, the subject to addendum, the disclosures, all of that, it's executed. We'll even circulate by DocuSign, do the whole thing. We submit it to title. It goes to title and boom, title takes it from there. Sometimes they have to come back. Title may not want to do the note and deed of trust. They'll come back to us and there's an additional fee to have us do, the wrap note and deed of trust or the performance note and deed of trust. But at the end of the day, it's a cost, but it's not, in my view, a huge expenditure to make sure that you're, protecting yourself and doing what you're supposed to do in the transaction.
Yeah. So I think what you mentioned is very important that, as a lawyer who does creative finance, you also know title companies who do creative financing because when you're doing a deal, you need a team, right? So,
Right.
how is having someone like yourself be a part of our team, a good thing in terms of your connections?
Yeah. I mean, you need insurance, and insurance is a complicated thing on a subject to, like, okay, do I leave the seller's insurance in place? Do I submit my own insurance policy to the lender? How do I list the seller on that insurance policy? Will the lender accept it? Do I go and just buy my own separate policy as the buyer? What do I do right on the insurance? Do I add myself as an additional insured on the policy? All of that. Well, I have an insurance agent that I'll send you to, and they'll take care of it. I have a title company. I have a loan servicer. If you want to put a servicing agent in place to collect the payments and write the check to the lender, we'll take care of that. Basically, from start to finish, I pretty much have the people you need to make the transaction go, if you will.
That's great. And so let's talk about if I was wanting to approach a creative finance lawyer, what would I have to have prepared in order to make a fruitful conversation? Um,
Really just, I mean, you just need to have the property address and kind of a rough outline of your transaction points. as much information you have on the loan that you're going to be, taking over, or yeah, you're not formally assuming, you're doing what's referred to as a silent assumption, but yeah, that you're going to be basically assuming. You need that information. But, have we had clients come to us and like, I don't even know the loan number or whatever. And have we been able to paper the transaction the right way? Yes, because at least here in Maricopa County, if it's in Maricopa or some of the counties, larger counties in Arizona, we can just go grab the deed of trust information and say, hey, it's the loan evidence by this deed of trust. And then for the purchase price, we just say, it's estimated to be this amount, but the actual purchase price will include the payoff amount of the existing loan as of close of escrow. And then the title company just goes and gets a payoff. And then, what the exact payoff was and what the exact purchase price was. So we can do all that with honestly, very limited information. Like, you don't have to submit a bunch of paperwork or documents to us. Just kind of tell us what you're wanting to do, how you want it structured. We'll fill it in. Sometimes we're missing a few pieces of information. We'll send you the draft of the purchase contract, highlight where we're missing stuff, say, hey, we need to know what you want to do here or there. They fill it in, get it back to us, and then they say, yeah, it's a go. And we show it to, whether it's the buyer or the seller, whoever the opposite side of the transaction is, they approve it. And then we circulate it for, signature by DocuSign, submit it to title, and there you go.
Yeah. So, do you have any real life stories that you could mention that could, give an example of how the transaction would go? For example, seller position, and kind of situation, so that someone in the audience could be like, oh, this is when a creative finance strategy would be best.
Yeah. So one scenario that happens would be, so you have now in this case, the seller's coming out, smelling like roses. And so it may not be the greatest thing for an investor, but I'll just throw it out there so you can start thinking about these things.
Yeah.
Let's say you have a homeowner owns a property. They have one of those great 3% loans.
Yeah.
And they live there for 2 years and they turn it into a rental.
Yeah.
And they rent it for, say, 2 years. Well, what happens at the end of 5 years? At the end of 5 years, they no longer can claim their capital gains exception because of the fact that you have to live there 2 out of the last 5 years. So basically, you can live somewhere for 2 years, rent it for 3 years, sell it, and as long as you're within that initial 5-year period, you don't pay capital gains. I think the capital gains exclusion is like $250,000. Mm-hmm. All right. So let's say you have somebody who's in that scenario. They're on year 4.5, and they need to do something with this property. Well, think about this. Let's say that the property is worth $800,000. There's a $600,000 loan against, or 550, if I'm doing the math right, $550,000 loan against the property, right? Mm-hmm. So that seller, if they could find a buyer who, maybe they sold their other house or otherwise, and they have, $250,000 to cash them out, they can cash out at 250. Then they can wrap their loan, but instead of wrapping at the 3%, they can wrap at like 6.5%. And so now they've sold their property and they've pocketed $250,000 tax-free. They pocketed $250,000 tax-free. And now they're getting monthly interest payments at 6% interest and only having to pay 3% interest to the lender. And so now they still have their cash flow, even though they've sold their property. Does that make sense? So,
Yeah.
there's different ways to structure this stuff to take advantage of, taxes and your low interest rate. And honestly, sellers, once again, your investors are going to hate me, but sellers with these low interest loans, low interest rate loans, a savvy seller will be looking at these loans and the property and the potential sale as two assets. They'll be looking at the property and having a fair market value of the property, and then they will be looking at the loan and having that have its own value, right? Because honestly, with rates at what, 6-7% now, who wouldn't pay an extra 20, 25 grand to be able to take over a 3% loan?
Yeah.
I mean, it's definitely one of those things that, makes sense. Now, from an investor standpoint, investors are going to be wanting to look for those situations where you have the low interest rate loans, and you haven't seen a lot of appreciation, and people either need to dispo the property's in, needs repair, needs work, or they can't afford to make the monthly payments on the property. In those cases, investors are going to find their deals normally. Now, if somebody purchased their property, early 2021, mid 2021, when rates were still kind of low, there hasn't been significant appreciation since then. A little bit of appreciation. And because of that, investors, if somebody has to move, meaning they've planned to live there, but all of a sudden a job relocation, a family issue, whatever the case may be, they need to move. In that case, they may be in a prime position where they can't really get much out of the property. There's not much equity there. So they might be willing to allow somebody to take over, their low interest rate loan.
Yeah. Yeah. So it makes total sense. And this is kind of on a note. It's similar, right? So essentially when someone's selling the property and cashing out their equity, and they have a good loan, that loan has a value, right? Because it's a very low interest rate. And so someone could actually sell that loan to someone else for, the principal paid balance, right? And so that's why whoever's buying the property and getting the loan is actually, really getting a really good deal. But the owner could also, sell the equity and sell the loan on its own and make that extra 2 or 3 points.
Yeah. So they're not, they're selling the ability to keep the loan in place and make the, low interest payment. That's what they're really selling. So yeah, they're selling the ability to, or they're selling the right of somebody or the ability of somebody to come in and basically assume that, loan, if you will.
Yeah. And so let's talk a little bit about multifamily.
Yeah.
Does the creative financing that is done in single family, does it apply to multifamily?
It does. And what's interesting is, at least here in Arizona, the multifamily is a whole different ballgame because the due on sale is very limited in the commercial space here in Arizona. So back in the 80s, early 80s, we had a line of authority. In fact, we had a decision by our Arizona Supreme Court, which basically said that a lender could not enforce a due on sale clause as written. Instead, the lender must show that its security was being jeopardized as a result of the transfer. So the significance is, does the new buyer have the ability to pay? Are they a greater credit risk than the original borrower? And second, is somehow their lien no longer in the same position? Well, the savings and loan lobby, the credit union lobby, they did not like those decisions. And Arizona wasn't alone. They were happening in other states throughout the country. California being one of them. And so they ended up, coming back and passing federal legislation called the Garn-Saint-Germain Act.
Hmm.
And Garn-Saint-Germain basically said when it's residential property and a federally insured loan, which almost every loan is federally insured, residential property and a federally insured loan states you must enforce the due on sale clause as written, says the federal government.
Hmm.
And that's called federal preemption. And the states must listen to them and abide by their, legislative declaration. And so all of a sudden now, back, in the 80s, early 80s, Garn-Saint-Germain comes in and says, nope, you're going to enforce it as written. There's no exceptions. And, but it did make some exceptions for certain transfers, right? Like, if somebody dies, their heirs can inherit the property without the due on sale clause. If you transfer to a family trust, there's all these different exceptions, divorce, those types of things. But otherwise, to do what people are wanting to do in the subject to world, the wraps and things like that, Garn-Saint-Germain says, no. Enforce the due on sale clause as written. However, Garn-Saint-Germain only applied to residential loans.
Hmm.
So in the commercial space, in the multifamily space, and multifamily being more than a duplex, in the multifamily space, that Garn-Saint-Germain's not going to apply and won't preempt our current state law, which basically says, hey, if you go and you convey, this property, and don't get the lender's approval, and the lenders can't just invoke the due on sale clause as written, you're going to have to show that, hey, this is jeopardizing our security in the property, our loan, et cetera. And if you have a decent buyer that can show financially, I'm just as good as the original, borrower or seller, I don't know that the lender can prove that. And the burden's on them to prove it, by the way. They have to file the lawsuit, prove it up, the whole thing. So to answer your question, this is a long ways of answering your question. Not only here in Arizona can you do subject to on commercial,
Hmm.
it's even better because the due on sale clause is more limited. You know what I mean? So yeah, by all means, subject to does work on commercial as well.
That's amazing. And there's another really cool strategy on the block called novation agreements.
Mhm.
Do novation agreements work on multifamily?
On multifamily, yeah, I don't see why they wouldn't. I mean, it's real estate, so you just have to remember in a novation, the end buyer has to be able to do and should be able to do their due diligence. And there's a lot more due diligence involved in a multifamily property than just single family residence or even a duplex.
Hmm.
And so you need to make sure that end buyer gets the opportunity to do it. But yeah, you could do a novation on multifamily. The seller may not like that because obviously the new contract is replacing the old contract. That's a novation, right? A novation is...
Explain what a novation agreement is.
Yeah, so the legal definition of a novation is replacing one contract or one obligation with another. So basically, two parties buyer, seller enter into a purchase contract, and the buyer and the seller agree that if a third party comes along and it's a better deal, that the seller can enter into the purchase contract with that third party buyer, and that contract will replace the original contract between the buyer and seller, so that the buyer no longer would have the ability or right to purchase the property.
Mm-hmm.
Now, it's important that it's structured correctly, because that only becomes effective. The existing buyer's cancellation should only be effective when the end buyer is actually closing escrow. And then the original buyer is compensated via a cancellation fee or a memorandum release fee. So they record a memorandum against the property that gets released at closing in exchange for payment of, compensation, whether you call it a cancellation fee, a release fee, whatever it may be. That's how that original buyer is compensated. But that buyer could be under contract for, say, 2 weeks, a month, and then the new buyer comes along. Well, they're going to be using a purchase contract. That new buyer is going to be using a purchase contract that's going to give that new buyer additional time to do due diligence and things like that. So, you just have to work with your seller, make sure your seller knows what's going on so that they understand, oh, well, that new buyer is going to have a right to review leases and inspect the property and do a survey and do an environmental and do everything that they need to do, to properly purchase the property. And so it could be done, but it's just a little bit more complicated than just say your residential where, most of the time the end buyer is an investor, understands the risks, and sometimes even just waives the inspection. It doesn't, worry about it.
Got it. And I wanted to ask a question on when you buy a portfolio of single families. Let's say we have an investor that likes to buy them up, and then they do a blanket loan for all the properties, and you happen to find that seller and you want to do it subject to, for example, on that blanket mortgage. Does that work?
Yes, depending on the language of the security instrument and the note. So, but it doesn't work in the traditional sense. And what I mean by that is you can leave the deed of trust against that property or the mortgage against that property. However, you need to make sure that the one thing that's in place, and this is the most important thing, is that there's a release price for that particular property. So normally when you do, let's say you have 50 properties all under one blanket note, and then each would be individually secured by a deed of trust. Normally the blanket note or the deed of trust would say, this is a blanket note. This covers all these properties. However, if you deliver $120,000 to me, we'll release 8560 Main Street. Do you see what I'm saying?
So there must be a release per property?
Yeah. I mean, if you're going to do a subject to, you better make sure that there's a release price per property.
Okay.
Now,
yeah.
The reason why I say it can't be taken subject to the traditional sense is because you don't have a monthly payment that you're making per property. So it's not like, oh, well, that $2,000 a month that you're writing to this lender for this particular property, I'll just step in and I'll write a $2,000 check, because that's not, it's a much bigger check. It's a check for 50 properties, right? And it's not broken down by property. And so it's like, so basically what you would do is you would do wrap financing. You would give the seller a note. The note would have its own specified interest rate, its own monthly payment amount, everything like that. I would probably insist on a servicer. And then I just write the monthly payment to the servicer. And then it's incumbent upon the seller to then, and the servicer to make sure that money is used to write the monthly payment, or at least make a portion of the monthly payment on the existing loan. But as long as that release price is in place, then if something goes south, at least hey, I could sell this property over here, and as long as I can pay $120,000 to the lender, we're golden, we're good. You see what I'm saying?
Yeah. Yeah. So once you have that check sent to the servicer and to the seller, then the responsibility is on them to make sure that the money is distributed to all the different properties so that there is not any default.
Right.
Got it.
And then I would put in, if I were representing the investor, I would put in, provisions into the basically the note and the deed of trust that basically say that, if that underlying lender ever defaults because they haven't made payment, that's a default under these documents, and then have some form of, penalty, like I don't have to pay payments anymore, and I can sell the property, or, whatever the case may be.
Got it. Cool. So I want to talk about, take it a little bit basic here and just go over a couple of the exit strategies that a regular real estate investor goes through. And, we just want to know your knowledge, your definition on them. So how is a wholesale transaction done?
From an exit strategy? Okay. Well, yeah, I mean, an assignment is your exit strategy, right?
Yeah.
So the investor never really takes title to the property. They only have an equitable interest or a contract interest in the property.
Mm-hmm.
So a couple of things that to be aware of with wholesaling. So number one, state required disclosures. So in Arizona, you have to have very specific language in your purchase contract as to, that you're a wholesale buyer, and that, you're going to, potentially assign the contract to an end buyer. If you don't have that language in there, the seller can cancel at any time prior to closing and keep your earnest money. So you have to have that language. And Arizona is not alone. Alabama just passed a similar one, and theirs is even worse. It's criminal if you don't have that language in there. It's a misdemeanor if you don't have that, including significant, like treble the actual damages and statutory penalties. I mean, I would not want to violate Alabama. Arizona, like, yeah, you lose your earnest money, it stinks, and the contract's canceled. Nobody wants that. But, like Alabama, like you could end up, in front of a judge being alleged to have committed a crime, like, oh man.
That sounds tough. I wouldn't want
So, yeah. So you want to make sure you have the state required disclosures.
Mm-hmm.
You want to make sure that, I always like in my purchase contracts, wholesale purchase contracts, to have a 10-day cure period, 10-day cure notice.
Mm-hmm.
And I'll tell you why in a minute. So you want a 10-day cure period. So if, the escrow date comes and goes, you're not able to close for one reason or the other, the seller has to give you a 10-day notice in order to cancel that transaction. And then third, the third thing that you're going to want, and here in Arizona, and I believe it's pretty standard across the country, but in Arizona especially, you're going to want, if you want to record a memorandum of your purchase contract, you're going to want it in the purchase contract authorizing that.
Mm-hmm.
If you don't have that, it's unlawful here in Arizona to record a memorandum. And there are pretty significant and strict penalties for unlawfully recording a memorandum. So you're going to want those three things in your purchase contract, along with many others, but those are the three, basics that always come to mind when we're talking about wholesale contracts. Then on the assignment, you're going to want a few things. So once again, state required disclosures. So in Arizona, you have to disclose that you're a wholesale seller, whatever that means. But basically, you're a wholesale seller, and that you do not have title to the property, and that your performance and ability to convey title is dependent upon the seller conveying title. And so you have to put that into your assignment. If you don't put that into your assignment, then the assignee can cancel and receive the return of their earnest money. Mm-hmm. The second thing that you're going to want in the assignment is you're going to want to exclude the assignment of certain rights to the assignee. So, Julian, if I have a property under contract and I say, oh, Julian, you want to, end up buying this, and I'll sign my purchase contract to you. And you're like, great. Yeah. So I assign it to you. I'm getting a nice assignment fee. Everything's great. And I just give you a blanket assignment because, you can literally assign something to anybody in like 2 sentences. It's pretty simple, right? I just say, hey, I assign to you all right, title, and interest in this purchase contract. And you basically say, yeah, I assume this purchase contract, and boom, you have it.
Yeah.
Well, I just assigned to you the full bundle of rights to that contract. Well, Julian, what happens if, the close of escrow date comes and goes and you're like, ah, man, Sean, I'm working on it. I have, some investors lined up, but they're not coming through. I can't perform. But I'm getting there. I'm getting there. Just give me more time. Give me more time. And that just keeps going on. And then finally what happens? I'm like, Julian, I got to pull the trigger on this. Like, you're out, and I need to be able to go and find another assignee, or I need to close myself with this seller because the seller's getting, restless and whatever. And you're like, well, you can't do that. I'm like, sure I can. I'm the buyer. It's like, you're not the buyer anymore. You just assigned your entire right, title, and interest to me. You can't just kick me out. I'm like, well, you missed the close of escrow date. Well, what about my cure notice? You don't get a cure notice. It's not an assignment. Well, but it's in the original contract. And you would be right. The seller would have to give you a cure notice, not me, you, because I've assigned my full contract rights to you.
Yeah.
Well, that doesn't do us any good because this deal's going to fall apart, right?
Yeah.
So instead, what I do is say, okay, Julian, I'm going to assign this to you, but I'm going to reserve for myself a few things. So one, I'm going to reserve for myself the benefit of the cure notice and not you. So you don't get the benefit of the cure notice. If you miss the close of escrow date, the contract automatically reverts to me and the assignment's canceled.
Mm-hmm.
Okay, so that's number one. Number two, I'm reserving, or I'm stripping from you any power for you to cancel the contract. I don't want you communicating directly with the seller. I don't want you going to around me. Maybe you're like, I don't really want this anymore. I just want to cancel and get my earnest money back. Well, I don't want you doing in and run around and going to the seller and, doing a cancellation. So I'm going to put in the contract that that no cancellation can be had of the contract without, my express written approval as the original buyer.
Mm-hmm.
So I'm going to put things like that in the assignment that basically pull back some of the rights that you have as a traditional assignee, so that we know that, hey, if this thing doesn't happen and you miss the original close of escrow date, what can I do? I can wipe you out. I can take your earnest money, say, Julian, you're out, you're done. And then I go back and either close myself with the seller, or I go find another assignee, and I have at a minimum 10 days to pull it off because I have a 10-day cure notice. See what I mean?
Mm-hmm.
So that's kind of how I like to lay out my wholesale purchase contracts and my assignments. Those are the issues that you have to be aware of in those types of transactions. Oh, the other thing I don't like in assignments, and title companies hate it, original buyers hate it, but the whole daisy chain thing. So I'm going to put in my assignment, like, you can't assign again without getting my approval.
Yeah.
And then all future assignees must come to me, for approval, because I want to make sure I know who's going to finally be closing on this, and because there's been transactions that I've been involved in that were like, who's supposed to be buying this? You know what I mean? Like, it's just been assigned 20 times, and like, who's supposed to perform? And then it's a real mess, and earnest money's complicated and the whole thing. So
Yeah. That sounds very interesting, and thank you for that. I want to talk about the subject to retail exit strategy.
oh yeah.
Could you give us a breakdown of that?
Yeah. So if you purchased a property by wrap financing, so you have fee title to the property, you've given the seller a promissory note and mortgage or deed of trust, you can then turn around and sell it on a wrap, where you carry back the financing. But that's a little bit different than what your acquisition strategy, because number one, you have to give a lot of disclosures to the end buyer. You need to make sure that the end buyer understands that you're not the original borrower, that they aren't going to have access to the mortgage information. that there's a risk that there's this due on sale clause out there, and there's a risk that that might actually, happen. You have to disclose about, insurance. So there's a number of disclosures you need to give to the end buyer to make them, hey, appreciate and aware of the nature of the transaction. And then your promissory note is going to be, more of a traditional promissory note, which basically is, instead of, doing, say, a mirror loan, or a portion of the promissory note is mirroring the existing payments, you're not going to have any of that, right? You're going to have the principal balance, the interest, the amortization, the monthly payment, the late charge, the whole thing. And it's going to be broken out like a traditional promissory note. But the documents are going to reference and explain to the buyer that, hey, you're buying this subject to the existing loan. Here are the risks, that type of thing. Now, if you've acquired a property subject to using an agreement for sale or contract for deed, then your exit strategy would be, another agreement for sale or contract for deed, or even an option to purchase, a lease with an option to purchase. But you cannot convey the property using like a warranty deed, if you will, because you don't have fee simple title to the property. You don't have the ability to, give a warranty deed, because no warranty deed was ever conveyed to you. So just be careful on that. As far as, a disposition, using that if you've acquired by agreement for sale, you can do a disposition by agreement for sale or by a lease with option. Now, if you've acquired by wrap, warranty deed, then your disposition could be another wrap. It can be an agreement for sale. It can be a lease with an option to purchase. There's a number of disposition methods at your disposal there.
Yeah. Thanks. What is a short sale?
Yeah, a short sale is where you go to the bank and say, hey, look, my property is no longer worth what I owe. I want out. So bank, will you agree to accept less than the full balance of your loan if I sell this property? And will you agree to release me from any liability related to that loan? That's a short sale. So you have to go to the bank, you negotiate, you submit documents to show why you can't continue to stay in the property, why you can't continue to make the loan payments. You have to, show why the property is not worth the same as it was before, why, how it's gone down, why it's worth less than what's owed. You basically go to the bank and try to negotiate a reduction in your loan in order to sell the property.
Cool. Yeah, thanks. So is the subject to retail, creative, the exit strategy, the same thing as a disposition as a wrap?
It may or may not be, depending on which method you choose. So you can wrap, you could do a agreement for sale or contract for deed. You can do a lease with an option to purchase. It really just depends on, part of it depends on your acquisition strategy, and part of it depends on what disposition strategy you like best. I have clients that like leases with options. I have clients that like agreements for sale, and I have clients that like wraps. And it really,
let's talk about the lease option.
Yeah.
Someone in the audience.
So the lease option is basically you lease the property as the landlord to who may be the end buyer, who will be the tenant, and you have a lease agreement. Basically, it looks like every other lease agreement, nothing special. And it shouldn't be anything special. It should not reference the fact that there's an option to purchase. It should have all of the state required disclosures. So Arizona, we have specific disclosures. It should, not provide that you basically, as the landlord, are, going to delegate your duties as the landlord to the tenant. As a landlord, at least here in Arizona, you have to, maintain a habitable dwelling. So you can't say, oh, look, tenant, because you have an option to purchase and you're going to later buy it, you need to go replace the AC unit. You need to, replace the heater. You need to replace, the electrical, the plumbing, you need to do all that to make the property habitable. No. That's not going to fly. And so, you as the landlord are still going to be responsible for those items. There are certain items with, at least here in Arizona, with proper disclosures that you can require that the tenant do, even though traditionally a landlord would perform them.
Mm-hmm.
But habitability is still a landlord responsibility, even if the tenant has an option to purchase. And then you have a separate document called an option to purchase that can be recorded, doesn't have to be recorded, but most tenants want it recorded because that protects their interests in the property.
Mm-hmm.
But the option to purchase will reference a lease and performance. And what I mean by that is it will say, hey, this option's only good so long as you comply with the lease. So the option references the lease, but the lease will not reference the option. And so if the tenant breaches the lease and is evicted from the property, bye-bye option. There is no more option.
Yeah.
Now, the problem with options, at least here in Arizona, is they can create problems depending on what happens in an eviction proceeding. If the tenant brings up the option, produces the option, and if an eviction judge is concerned about it or feels uncomfortable, they may say, well, this is a civil proceeding. You have to go quiet the title first and then come back and see me. And then you have a mess on your hands. Other times that's not an issue, but nevertheless, that's why the lease should not reference the option, because you should be able to do just a basic eviction, because the lease should be a standalone document where the tenants agreed to pay you monthly rent. And if they've paid, great, they can stay in the property. If they haven't, they should be evicted, type of thing.
Got it. So, what is the exit strategy? Which is you do, instead of like you know how the bird method works, right? Instead, you acquire with the subject to. Can you explain how that works and how people can make money?
Yeah, I mean, if you acquire by a subject to, then you can, and I'm not a lender, and frankly, as far as the weighting requirements and stuff, I don't know what they are. Mm-hmm. But I do know that you can acquire by subject to, and as long as you are the owner of the property, you can go and apply for financing. You can get hard money, whatever the case may be. You can go and obtain a loan that pays off the underlying loan and then puts money, in your pocket as a cash out refinance.
Mm-hmm.
So, I mean, and then you use that money presumably to go and buy another property or invest somewhere else. But you have to wait. I don't know. I think it might be 6 months or a year or something, depending on,
since purchase, you have to wait like a seasoning period. So
there is a seasoning period. I don't know what that is, but bottom line is, as long as you're the owner of the property, you have the right to refinance.
Yeah. Makes sense. All right. Sean St. Clair, thank you. And can you please tell us about your podcast in a little bit of detail, plus your website, and if you are on social media?
Yeah. So anybody can find more information about me and my firm. The firm is Fowler St. Clair. Mm-hmm. Our website is Fowler, as in the golfer, Fowler, then my last name, St. Clair, no space or period. Mm-hmm. So FOWSTCLAIR.com. So FowlerStClair.com. My phone number, and this is my direct line. Best way to reach me. Email's not a great way to reach me, but if you want to, talk, don't text me, just call me, leave a voicemail, or if I'm available, I'll pick up. My direct line is 480-359-7206. Once again, that's 480-359-7206. And as far as our podcast, it's called INRIM, the Law for Real Estate Investors. It's live every Tuesday at 10 a.m. Arizona time. You can also watch some of our shorts and old episodes on our YouTube page. So it's INRIM. If you go to YouTube, type in INRIM podcast, INREM podcast. So INREM podcast on YouTube. Like, subscribe. All the videos are there. And then our Creative Finance Collective, I wouldn't call it a podcast. It's more of just a meeting of attorneys who we, like I said, get together and talk shop at night. It's on Wednesdays at 5 p.m. Arizona time, and you never know who's going to be there. It's just an open invitation for attorneys to hop on and chat. So, we've had attorneys from Ohio and Texas and California and Georgia, not our firm attorneys, another attorney from Georgia. You just never know who's going to be there on that particular night. And we don't even know the topics. Some, we kind of have an outline, but it always goes a different direction than what we originally think, because somebody wants to talk about something, and generally it's pretty good.
Yeah, that sounds really interesting. Are you on social media?
Yeah. So on Facebook, you can look me up that way. Sean St. Clair. Also, I have a real estate or a group, a Facebook group called Real Estate Investor Legal. And the goal of the group is to basically allow attorneys and investors to have a space where they can ask for referrals, ask for, basic, legal information like, hey, what's the next step after this? Or what do I do here? It's not designed for specific legal advice. So don't post, your specific legal question on there. But if you show up to our podcast or you show up to the Creative Finance Collective, you can post questions, specific questions. We won't give you legal advice, but just general, more specific legal questions on there. The Creative Finance Collective, we take questions for the whole hour. On our INRIM podcast, we take questions the last 15 minutes. So I'm available 2 days a week. If you have a question, feel free to, jump on one of those opportunities and ask it.
That's awesome. Thank you, Sean. I think you'll be on my podcast soon, maybe talking about some other different strategies in more depth. So I really appreciate you coming on. And to the listeners, Sean is the lawyer for Pace Morby. This is how I was aware of him, and I wanted to bring him on because, with creative financing, he's definitely the one who has been helping Pace. So I believe he's a good resource for this group. So if you want, reach out to him at his personal line or any of the method that he mentioned. And I hope you have a great day, and see you next time.
Thanks, Julian. It was fun.
Thank you, Sean. All right. Bye-bye.